tried to do that about an hour ago.
Okay, I can try. Let's see if it's on the invite. So hello to all of you. My name is David Hall. I'm one of your lawyers. I've worked here about 15 years. And I used to do a lot of work in agriculture, not quite as much anymore. But my primary subject areas are commerce and economic development and housing, which includes things also like workforce development, which I've been working on this week feverishly, and business organizations, consumer protection, data privacy, all that kind of fun stuff. So that's usually where I spend most of my time. I don't actually see the Zoom link on here. Here it is. You just sent it.
Yes, yeah, it's not on the
Thank you.
So how did you assign this?
Well, it's, so it's a great segue. So the right to repair, let's call it a movement, has been around now for many years. And it this year manifested in two different bills, one of which applies broadly across sort of consumer electronic products. But this one is ag related to the extent that it only applies to agricultural equipment. So it's really a subset of the kind of work that I've been working on in this area for years.
Yeah. So
I think it should work.
You're there.
Yeah.
there we go. Thank you.
You just have to close out of that little screen and then go to your field.
Oh my God.
Can't teach an old dog new tricks. So again, I think the first one of these bills came through, I want to say in 2016. I don't know if that's right or not. I don't remember. I've had so many of them. And it didn't go anywhere the first time around, and then got a little more traction the next year, and then finally culminated in this building in a summer study task force, which I staffed, where we looked at all of the ins and outs of everything from intellectual property protections, warranties, Magnus and Moss Warranty Act at the federal level, copyright, trademark, the way that the movement began, where it has brought us to. Essentially, there was a groundswell at the federal and some states about trying to get the right to repair your products. And it was an analog to what happened with motor vehicles, where there was a push to get motor vehicle manufacturers to provide information to independent repair shops. And Massachusetts ultimately adopted by referendum a legislation that would have required that to happen. And if I recall correctly, the result was a compromise whereby the Massachusetts legislature withdrew that, repealed that, but there was a voluntary agreement entered between motor vehicle manufacturers and consumer protection groups and independent motor vehicle repair representatives, so that now it's resulted in the system where we have in place that independent motor vehicle repair shops can access online tools and databases and can buy physical tools to repair all the cars that we drive. That has expanded, I believe, in and beyond Canada. They are now, in the last few years, the last I checked on it, they were bringing large trucks and bigger commercial vehicles under the fold of a similar construct. But let me underscore that was sort of an industry, not led, but, agreed to compromise to get to where we are now. I think in this realm, Apple has most recently voluntarily agreed to offer their materials or expand the availability of their materials and their information to other groups. But I don't think, I'm not going to editorialize on whether that's sufficient for people. So this comes up in the context of ag equipment specifically. And, it functions much the same way. what we do is in any given one of these statutes, and I said I've drafted several of them. So there's the sort of across the board consumer equipment. There has been a bill in the past that relates just to like personal electronic devices, so computers and phones. And then this is specific to ag equipment. The construct is the same. We define what the universe of equipment that we're talking about. So here, agricultural equipment, it's quite a broad definition. Device, part of a device, attachment to a device designed principally for ag purposes. So that's tractor, trailer, combine, implement for tillage, planting, cultivation, other equipment, etc. We sort of go ahead.
So it's not including forest economy, big equipment.
Well, I think it could. It depends on.
Get to later definition.
Well, it's not under definitions, but later it talks about forestry equipment. So my question here under definitions would be, are trees part of horticulture or floriculture? I don't know what floriculture is. Is that forestry is considered an agricultural
Right. Well,
business?
if you look down at, if we are just going to jump right ahead to the requirements, it does apply to agricultural and forestry equipment. So let's not worry about words for the moment. Let's talk about concepts. So agricultural forestry equipment is our universe, however we're going to end up trying to define that. We're going to break the world into authorized repair providers and independent repair providers. And the law, if you pass it, says if you are an original manufacturer of any kind of this qualifying equipment, it is your duty under the law to provide the same information, diagnostic tools, repair tools, computer code, whatever, to independent repair providers and to individual consumers as you make that available on the same terms and in the same scope as you make available to your authorized repair provider. It doesn't say you have to give it to them for free, but it says you have to make it available and they have to be able to buy it on comparable terms, fair and reasonable terms. In a nutshell, that's what this bill does. We can pour over the words on the page if you want to, or we can take another conceptual step. Do you want to do the latter?
Yes.
Another conceptual step would be,
Problems that arise with any one of these bills,
yeah,
which are significant in my estimation.
yeah, are people good with that direction? Yeah, let's do that.
Okay. So I am not a judge, and I'm certainly not on the Supreme Court. You all have the ability to adopt legislation that you think is prudent, and if it ultimately gets challenged, that's going to be up to a court to decide whether it is constitutional or not. But it is my job as your lawyer to identify to you potential problems that I see, and I see them here, and I have for years. And let me sort of name those off. The first one is a contracts clause problem that I see, whereby we have manufacturers who have entered into these contractual relationships with, authorized repair providers. And there's at least an argument that I would be almost certain that if this law passed, it would suddenly require the manufacturers to breach those contracts by providing information, documentation, services, et cetera, to people who are not within that fold. How big of a problem is that? I don't know.
That's the independence.
No. There's a manufacturer who says, I'm going to set up this authorized repair network, and in exchange for whatever it is, license agreements, maybe you pay me or maybe I pay you a favorable rate. I don't know what. You have to go to my school. You have to be certified. If you do all that stuff, you can be authorized. And then we've got this agreement where if you do that, you will be the people who benefit from the contract and are allowed to make the repairs. I won't let other people do that. I won't give away the farm. I'll share my intellectual property and my stuff with you only. So if we start saying now everybody gets access to that same information, that contractual agreement has been jeopardized. That's at least one argument I would make. Another one is, here's a Commerce Clause argument for you, which I find interesting. So in that same construct, if we suddenly say, now we're going to allow independent repair providers and individuals to have all these same rights, what if the manufacturer is set up to have authorized repair providers not in this state? Suddenly, we were having a very significant impact on interstate commerce, and it is to the benefit of our in-state interests at the expense of out-of-state interests. So for instance, last example I heard was Sony only, allows them to send their equipment to a couple of places around the country. Those are the people who are authorized to work on your device under the agreement. If suddenly we said, Sony, you now have to give all of these independent Vermont shops all the same data so that they can fix the computers, and that's going to come at the expense of the business you were sending to Indiana, that's at least a potential problem. Is it a winner? I don't know, but it's at least a problem. Another one, and this is, I'm not sure the extent of the problem here, but it's an interesting argument, is a potential takings argument. Like you are depriving potentially both the manufacturer and the authorized repair provider of their, property, basically their intellectual property, their economic interest. They have investment-backed expectations in, maintaining the propriety of this information and of these relationships. And if you start forcing them essentially to give away their intellectual property and access to their tools and equipment, how much of an economic loss is that for the manufacturer, for the authorized provider? I don't know. I don't know that
They're not giving it away. It's not just like, here's the code. I mean, there's a fee involved so that can be established. As you just said earlier, it's not just, so we're shifting the landscape, but we're not just saying, give it away for free. We're saying, if people want to buy into it, they can.
maybe.
But these arguments are all of them can be argued against, but
Sure.
but they're still valid.
I don't know if they're valid. I'm just
Oh.
raising the concern.
Yeah.
But it's a good point. But so the counter argument I would make, though, is now every single one of us with an Apple device now suddenly has access to whatever codes, equipment we need to tinker, mess around with our iPhones or our iPads or whatever else. I mean, how long is it before that completely devalues the proprietary information that Apple has invested in its products? I don't know.
Right?
I just wonder if there's value in remembering that we're not talking about tinkering with iPads, but tractors, and we can sort of just.
Well, so
I know that other
tractor is a very expensive iPad. I mean, right? I hear you. I hear you, but if
Owned
you
by a much smaller segment of the population, and
sure, but magnify the cost of $1,000 phone by $180,000 piece of equipment, and you might get to the same place. I don't know. My point is, it is an economic risk to the proprietary owner of the information. And whatever consequences come with that. Is it a winner? I don't know. The last one I would say, and this is the one I have probably the most concern about, is I would view this as it's at least a risk to be construed as a court as compelled speech. And by forcing businesses to give away this information, or not give away, as you said, to sell, but still to engage in this practice that they otherwise would not, and to give away intellectual property, give away written materials, it's at least theoretically possible under the sort of the scope of the jurisprudence of the
Bill, today.
So I'll hold the calendar.
Yeah, I'm just sending off an email right now.
Sorry, thank you.
Okay, thank you.
So this, this can be somewhat esoteric because there's a difficult line to define between what is the regulation of speech and what is an economic regulation that impacts speech. And the tension is between the First Amendment and the police power. The police power is the source of state authority to regulate the public health, safety, welfare, morals of the people. And it's the thing that allows us to do everything from criminalized behavior to say, you need to warn people that there's mercury in a lamp. But at some point, it stops being economic relation that impacts speech, and it starts being the actual regulation of speech. And I think a lot of people would be surprised at how far that can run. So for instance, when we lost the IMS v. Sorrell case, which had to do with pharmaceutical, with drug companies and the prescription practices of physicians, the Supreme Court said our regulations preventing the sale of this data and the ability to use it for marketing were actually speech regulations. They were not marketing regulations or economic regulations or health or consumer protection regulations. That was the regulation of speech. And my fear is the way that jurisprudence has been moving, where commercial speech has been receiving more and more protection over the years, could be implicated here. And, the state forcing these businesses to, say things, do things, transmit written and spoken information in a way that they otherwise would not want to, could be construed as an unlawful, compelled commercial speech case. So whether that one's a bad one or not, I don't know. But it's one of the ones that are on the menu. And that doesn't get into, sort of intellectual property rights, which I'm not an expert on. And, I think there's a lot of gray area in that realm. I'm not going to try to go down that path, but anyway, so there's concerns.
Before we go on.
Just while it's apropos, so were these some of the considerations in Massachusetts then in that original auto?
So I don't.
Why they repealed it? Because
Sure.
if it's voluntary, right?
Right.
Not these issues.
I don't know if these issues came up at the time. It was, like I said, it is a voluntary construct that has allowed it. I think obviously there's been great success in pushing this forward and trying to reach a voluntary resolution. But if that doesn't work, obviously you press it in a forum of statutory or rulemaking process, right? So I don't know whether these issues have come up. So that's all the gloom and doom. Back to the concepts though, in a nutshell, like you said, it's not exercising state authority to force them to give things away, but rather to make them available on fair and reasonable terms to independents and to individual owners on the same material terms as they do to their authorized repair providers. Whether that's, advisable is completely a policy choice that you get to make, not me.
And I mean, is it fair to say, David, that generally speaking, when we're considering legislation, we of course want your opinion and input on constitutionality and so forth, but we will proceed as we see fit, not worrying so much about whether somebody might bring a suit. Leave that to the future.
Yes, no, it's certainly as I said at the top, you're the legislature. And even if I sat here and told you, whatever you're going to do, I think is absolutely unconstitutional, it doesn't matter. Because it's not unconstitutional until a court says that it is, which obviously requires somebody to sue us, which first requires you to adopt the law. So my job is to point out the icebergs, and it is your job to navigate.
So I know that some folks will need to leave possibly before we're finished with this conversation. And I see Representative Templeman's got a question. So why don't we take your question, and then maybe you can just sort of give us the high level, point out what you feel we want to pay special attention to language wise, David, but David Templeman, go ahead.
So regarding these concerns that you're putting forward, I would imagine that should we vote this favorably in and it becomes statute, what you're suggesting may happen is a lawsuit.
I have no idea.
I'm
It's at least
aware
a
you don't.
possibility.
I'm just asking, like in a, hypothetical world, is
Sure.
it a strong possibility?
I have no idea.
Yeah.
You would have to hear from agricultural and forestry equipment manufacturers.
I think we'll find out tomorrow if there's a chance of a lawsuit.
Has this happened
Attorney
anywhere
General.
else that we can draw upon as a
This
example?
this type of no.
Okay.
No, this, to my knowledge, this still a fair repair or right to repair statutory framework has still not been adopted in any other state. I haven't looked at that, in the last year probably, but it has been introduced in a handful of states, and I don't believe it's been adopted.
Thank you.
So yeah, let's just go through.
Sure. So, general considerations, obviously, when we're talking about the universe, I mean, you'll want to make sure, so for any given law that imposes a duty, right, it answers the question who must or may do or do not, right? And then it's the who and it's the what. Here, the who is the original manufacturer must give what to whom. And so, ag equipment, you'll want to look at this definition. Does this capture everything that you want, or is it too broad? Is it too narrow? Is it vague? I mean, it's a device, part of a device, or an attachment to a device designed to be used principally for an agricultural purpose. As you've already pointed out, what is agriculture? There's 20-something definitions in the statute. What does it mean to be designed principally for an agricultural purpose? I mean, we kind of know it when we see it, but does that need to be more specific? I don't know, maybe. Or maybe it's good how it is. The including language, that construct, obviously, for purposes of our statute, it means including but not limited to. So this includes, but it is not limited to tractors, trailers, combines, implements for tillage, planting, cultivation, other equipment associated with livestock, crop production, horticulture, floriculture. It doesn't have any limit on the size. So even though I, dropped a $180,000 John Deere, maybe it's just the $20,000 John Deere, or maybe it's a walk behind rototiller that's only $800. I don't know. It doesn't say for an agricultural business purpose. It just says for an agricultural purpose. So this could, does this include a shovel? I don't know. I mean, obviously it's not being flippant, but that's the range is quite broad. I think authorized repair providers is pretty, clear. It means you have an arrangement with the OEM under which the OEM gives you a license to use these trade names, service mark, proprietary identifier, et cetera, to diagnose, maintain, repair the equipment of the OEM. Documentation is important because it's one of the things you're entitled to have access to. That's any manual, diagram, reporting output, service code description, schematic diagram, security code, password, or other guidance or information used in affecting the services of diagnosis, maintenance, repair, etc. I don't think we need to dig in too deep to fair and reasonable terms, but that means basically with any of this, parts, tools, software, the costs are fair to both of the parties. The terms are, more or less the same as what you would extend to your authorized repair provider. And it goes through whether it means for the tools or for diagnostics, other things. For documentation has, more gloss on that. To that same point above, the universe, forestry equipment, So non-divisible equipment, implements, accessories, contrivances used directly and principally in cutting or removing timber or other sold wood, forest products, including equipment used to construct, maintain, or install infrastructure necessary to and associated with a logging operation. I mean, what does that mean? That could mean the heavy equipment you need to put in a logging road, right? I mean, that's a extremely broad definition. So I guess with both of those, agricultural equipment, forestry equipment, on the one hand, we know it when we see it. On the other hand, the universe needs to know, am I subject to this law or not? And that's sort of just a best practice for legislation, right? Independent repair provider means basically you're not an authorized repair provider. The OEM is the person who's in the business of selling, leasing, or supplying this equipment. That's an interesting one too, though. So original equipment manufacturer means a person engaged in the business of selling, leasing, or otherwise supplying new agricultural or forestry equipment manufactured by or on behalf of itself to any individual or business. So you do have to be the manufacturer, and then you're selling that out to the dealer. So I guess that's okay. It caught me up there for a second because I thought, could this be applied to the actual dealers who are out there? But I don't think so. Part, tools, trade. I think those are all pretty straightforward. So the requirement, we touched on, and we've only got a couple pages left, so I think it's important to read this. Here's what the duty is. Here's the what. So for agri or forestry equipment and parts sold or used in this state, that's another flag right there. So sold or used in this state.
What if we changed it? Instead for agricultural forestry equipment purchased in this state for use for agricultural, whatever, original equipment, and make it limited to things that you bought in Vermont.
What's the flag there, David, for you?
Extraterritoriality under the Commerce Clause.
What does that mean?
It means when we impose legal duties and obligations on people who are not in our jurisdiction and try to force them to comply with our laws. So
This is global too.
right. So it's not a problem if you have a relationship like in the state. For if you're John Deere, you've got a dealer here. You're selling you're manufacturing your tractor, you're sending it to your dealers here. The dealers are in business in Vermont. Not a big deal. What's tripping me up, what's giving me pause is for those who don't buy or sell their equipment in this state, it ends up here. So now there's a Vermonter who owns a piece of agricultural equipment that they bought from whomever, and they're here using it. And now we're saying, you manufacturer who has never set foot here, who doesn't do business here, who didn't sell that here, you need to follow our law and supply our resident with all this material. I'd have to think through that, but that's giving me heartburn.
So you're not talking about a secondhand piece of equipment, you're talking about a brand new piece of equipment.
It could be either one. I mean, it could be either one.
Yeah. Representative.
Just a quick question for the farming folks. How often do you buy a piece of equipment that you don't buy in Vermont?
Often.
Yeah, I'm just gonna give an example of like Vermeer, the brand of haying equipment. They don't have a dealership in Vermont anywhere, but there's one I think in southern New Hampshire and in New York. So if you wanted that piece of equipment, you'd have to go to a dealer there and buy it.
Okay.
And another example, I bought logging equipment in Bangor, Maine from Nortrax. They had a dealership in Vermont. All the paperwork, they required that I may have to pick it up in Bangor, but the paperwork, taxation, any terms come out of Williston. I have bought privately
Okay.
in Fort Kent, Maine, and in Corning, New York, privately, and that's a different story. But Anderson Equipment does represent those Swedish manufacturers here in East Montpelier.
Okay.
So that's, I didn't have to buy it through Anderson. That's where I have to go for parts.
Got it. Okay, well, let's keep going.
All right. Make available for purpose of diagnosis, maintenance, repair of equipment to any independent repair provider or to the owner of electronics enabled agricultural equipment manufactured by or on behalf of or otherwise sold or supplied the OEM on fair and reasonable terms. Documentation, parts, tools required for the diagnosis, maintenance, repair of such equipment and parts for such equipment, including any updates to information. An original equipment manufacturer shall make the documentation, parts, and tools available either directly or through an authorized repair provider. For equipment that contains an electronic security lock or other security-related function, the OEM shall make available to the owner and to the independent repair provider on fair and reasonable terms any special documentation, tools, parts needed to access and reset the lock or function when disabled in the course of diagnosis, maintenance, or repair of the equipment. Such documentation, tools, etc., may be made available by means of an appropriate secure system. I don't quite know what that means. Enforcement is important. So the way that we set up enforcement for lots of things is by tying it to the Consumer Protection Act in Title IX. That's the citation here, 9 VSA 2453. That is our quote unquote mini FTC Act. It's quite broad. It says, a person shall not commit an unfair, deceptive act or practice in trade or commerce. If you do that, if you do commit such an act or violation, then it comes with it this suite of enforcement mechanisms that are can be effectuated by the Attorney General, the state's attorneys, and there's a private right of action, which also involves the payment of attorneys' costs and fees and up to triple damages. So if somebody commits a violation of the CPA, AG has the ability to bring an enforcement action. They can get your records. They can bring you to court. They can issue what's called an assurance of discontinuance to stop the action. If you break that, there's worse civil penalties and fines. Then again, if an individual consumer suffers some sort of harm due to a CPA violation, they can bring their own civil action and again, try to get cost, fees, and triple damages. So that is the enforcement mechanism for a violation of this chapter. So limitations, nothing shall be construed to require an original equipment manufacturer to divulge a trade secret to an owner or an independent service provider. I don't know what I don't know about what these businesses would say is or is not a trade secret. So is this an exception that swallows the rule? I have no idea. You're going to have to hear from real world people who live beyond this building. But what I'm thinking of, if you need schema for that, is to say, our design for how to unlock this is a trade secret, or our code that underlines the operation of this machinery, it's a trade secret. Are they going to make that claim? Of course they are. Will it stand up? I have no idea. So I'm not sure what the result is there. And then again, no provision in this chapter shall be construed to alter the terms of any arrangement between an authorized repair provider and OEM, including the performance provision of warranty or recall repair work by an authorized provider on behalf of the OEM pursuant to the agreement, except that any provision in such terms that purports to waive, avoid, restrict, or limit the OEM's duty to comply with this chapter is void. So that's the contracts clause issue I'm raising, where if there is part of that arrangement between OEM and authorized provider that says, we won't give this information or these tools or this equipment or this code to anybody else, only to you in exchange for your agreement to do authorized repair work, to take our classes, to learn the stuff so you don't break anything, to be our, licensed representative in the world. That's potentially a problem. That said, I also should say states don't usually lose contracts clause challenges. And in fact, we do things that probably violate it all the time. In the early history of our country, the contracts clause was the single biggest basis of overturning laws through the 1820s, 30s, because independent state legislatures that were new states would just repeatedly undo private arrangements during the time leading up to the foundation of our country. And so, it was a real problem. That sort of just stopped and the jurisprudence moved in a different direction. And when the Commerce Clause really became ascendant in the 1920s and 30s up until today, that's been the main basis for challenging, raising economic type challenges, not the Contracts Clause. So I'm not trying to overplay the significance of the problem. It's only been a handful of cases that served as the basis for overturning the law in the last 100 or so years. But again, it's my job to flag the issue, right? The applicability is to equipment sold or in use on or after the effective date, and that would be this summer.
We didn't spend any time on it, but in the definition section, the last definition is trade secret and refers
Yes.
to
Right.
601,
Yeah.
which I don't know if maybe we don't want to dig into that right now, but
What page are you on, Chair?
that's on line 17 of page 6, definition number 11.
So a trade secret, as incorporated by reference, means information including a formula, pattern, compilation, program, device, method, technique, or process that derives independent economic value, actual or potential, from not being generally known to and not being readily ascertainable by proper means by other persons who cannot obtain economic value from its disclosure or use, and is the subject of efforts that are reasonable under the circumstances to maintain its secrecy. So it's a bit of a tautology in this chapter to say we're not requiring you to give away trade secrets, when in fact you're probably at least arguably requiring them to give away trade secrets. I know that the folks in the fair repair community are probably freaking out about me saying that right now, and you can hear from them on the other side. What I'm saying to you is I don't know the answer of how it implicates trade secrets or not, but I cannot see a situation in which they won't at least a manufacturer wouldn't at least argue this is a trade secret.
Jed?
Maybe I'm dense here, but Section 3, applicability, this act applies with respect to equipment sold or in use on or after the effective date of this act, and that is July 1, 2023. If you own something prior to that,
I think
still operating, or only after it was acquired?
well, it's sold or in use on or after the effective date. So I would read that to mean you just drove your skid steer up into the woods on July 2nd. Therefore, it's covered.
Right, but every farmer or logger in the state has stuff that's 30 years old, 40 years old, 10 years old, or 4 years old. and they're trying to repair it, is that not applicable under this
Sure.
applicability section?
I think a literal reading would say, yes, it is covered. And so, is that a good policy choice? Could you change this to say first put into use after the effective date? Maybe. It doesn't change the problem that you identify, which is, if I buy a used piece of equipment on July 2nd and bring it to Vermont and put it into use, it could still be 30 years old. So now does that OEM of that have the duty to comply with this? Arguably, yes. I think that's a question of scope that's appropriate.
And what they'd be complying with is again, making the same information that they're arguably supplying to their authorized dealers, now making it available to you or to an independent dealer.
Yes.
And one way to address this, I mean, if there's a concern about the date, the timing, which, might be a reasonable concern, the dates could be changed. Doesn't take effect till next year, or whatever length of time might seem to be appropriate.
As long as this isn't only going to protect people who buy stuff or use stuff after July 1, 2023, because that won't happen. Now a tractor isn't 180, it's 480,000. Or a piece of logging equipment could be $500,000.
Rodney's got a question, and then Josie.
I just got to state that. The first thing I see happening if this bill was to pass, uphold other challenges, price of equipment to the farmer is going to go up. Because if they lose any revenue in repairs, they're going to charge more for the equipment.
That's the unintended.
Josie.
My counterpoint to that is, I don't think that's what's gonna happen. I think they're gonna make the manuals and everything so expensive that no one's gonna be able to afford it.
And
I have a question.
By the way,
So
very add
is
on.
what about the contract between, I'm just wondering about that applicability part. If somebody bought a piece of equipment, let's say I bought a tractor 2 years ago. Is me buying that equipment, isn't that a contract essentially of understanding that I'm buying that equipment knowing that I can't have that diagnostic? Is there a breach of that contract? Does that make any sense? Am I making sense? Like,
As is, where is.
when I bought that,
Mm-hmm.
I was assuming some sort of liability, wasn't I, knowing what I was getting into? Is there an argument there or not?
I don't think unless that's specifically addressed in the terms of the contract, then I don't think that arises.
Okay.
well, John, you want to make the last question? Then the 5 o'clock.
No, I mean, just smaller stuff like what you were saying earlier about ag equipment. I mean, is it defined by usage, like I know all these United Ag, I think, make most of their money selling lawnmowers now. And so is that agricultural, is that suburban, or is it, I use a lawnmower to mow my orchard, it's ag, if the next door neighbor mows his lawn, it's non-ag, so I mean, it's just, these are the kind of rabbit holes we go down.
So without a reference in without a definition of agriculture here, it is maybe a little too vague and would need to be tightened up. Unless we intended to have it include lawn mowing equipment.
Like dump trucks, right? Like municipal dump trucks, if I buy one to carry silage and corn, is it then an agricultural?
And become, yeah, or the road building equipment.
Right, exactly.
maybe it's time to stop for the day.
Tis.
Resounding.
That's Irish for yes.
Thank you, David. I think it's been helpful to not just take a closer look at the language, but also get sort of the problem solution paradigm out there and to, understand what some of the pitfalls might be. I'm sure we'll hear more about those tomorrow when we take some more testimony, and I think we'll want to, you're doing lots outside of this committee, but we'll want to stay kind of close to you if we think we want to do any markups on the bill at all.
I think I shared, it was only with you, the report from the Fair Repair Task Force and the memorandum. So if you want me to send that to Laura, for the rest of you to be able to access.
Why don't you do that? That would be helpful.
Sure.
You don't have enough to read, so.
All right.
Okay, any other final thoughts, comments? Okay, good. I think